All right. So once again, welcome. I'm honored to have two gentlemen that'll be helping us out this evening in our discussion. We've got Nicholas Patton with the Neighborhood Legal Services Program. He'll be talking to us about tenant rights during eviction. We've also got Kelechi Agbakuru from the Washington Lawyers Committee, who will be talking to us a little bit just about the right to organize, right? The right to go into these buildings and help spread the word about tenant protections. So they'll be coming up in just a sec. I want to share right quick our agenda, just so we're clear, very brief, basic here. We want to do some welcomes and ground rules. I just did the welcome. So let me just say the ground rules. If folks would try to stay muted, please. And if you need to, you have a question, feel free to drop it in the chat, raise your hand. After each presentation, we will create some space for questions and answers as much as we can. A lot of the things that we'll discuss tonight are changing. So, we're going to try to give you an update at this point in time where we are with some protections and some of the work that's happening. We'll have Nicholas give us a presentation on that. Actually, before that, I'll give you guys an update on some outreach that's happening around protecting residents who are slated for an eviction or a court date. Kelechi will present around the right to organize. We'll have some, as I mentioned, some question and answer, some next steps, and then we'll close for the evening. Does that sound okay with everyone? Okay, wonderful. I've got a little poll here just so we can capture some information. I'm going to launch it. If you would just take a sec to answer each of these questions, that would be great. There are 4 questions. The first one is, what ward do you live in? We just want to know what wards folks are representing. Then the second question is, are you currently in ANC? We want to make sure to be meeting our ANCs. Have you seen a rise in eviction in your neighborhood? And are you interested in volunteering to spread the word? And we'll make sure to follow up with everyone. All right, looks like we have a concentration of Ward 3, 4, 5. Oh, here's a 6, okay. We'll just give it one more minute for folks to fill that out. If the folks who are ANCs, if you wouldn't mind dropping your name and your SMD in the chat, that would be very helpful. I know some folks are just joining us. Welcome. We are just answering some brief poll questions just for us to have an idea of who joined us this evening. I've asked if you are in ANC, if you could drop your name and SMD in the chat, that would be great. If you feel comfortable doing that. I'm going to give this just another second and we will get, we'll wrap this up. Okay. All righty. Well, thank you everyone once again. I wanted to let you all know that Empower DC, along with several other organizations, LEDC, the Latino Economic Development Center, ROC DC, the Restaurant Opportunity Center, and DC Jobs with Justice, along with a group called Movement Matters, have come together to do some broad outreach around the city. We are working with several legal providers, Neighborhood Legal Services Program, Legal Aid, Bread for the City. We're all working together to, as much as possible, try to connect people who are either facing an eviction or have a scheduled court date with legal support. So we are going out just about every day now, connecting with folks, knocking on doors. We have access to the lists of people who are on either of those roles, the eviction or the court dates. So our job really is to knock on the doors, make sure to connect folks with that legal support, and try to, the best we can, avoid any evictions. So we are doing that around the city right now. In Power DC, we are focusing in on Ward 8. If you are interested at all in either volunteering or just want to do some broad outreach, if you have a concentration of apartment buildings in your neighborhood, we can certainly provide you with some information and a flyer that we've been using to connect folks to that. There's a real big need out there. As we've been out there, we've encountered people who have already been evicted. So that's just going to unfortunately continue to rise, the eviction rolls, and hopefully these efforts can help to slow that down. And then, of course, to really create an environment here where folks know where to turn to and what to do, how to prepare. Unfortunately, one of the biggest issues is a lot of folks just don't show up to their court date. So that's another kind of benefit of this outreach, is that we're actually reminding folks you have a court date and you have to be present. Otherwise, the judge will most likely, rule in the favor of the landlord and give possession back to the landlord, which is unfortunate. So those are the efforts that are underway right now. Hopefully they'll, as I mentioned, we're working Ward 8, but several other organizations are going to be working around the city. If you, as I mentioned, feel the need or are interested in doing this sort of work in your general neighborhood, let's make sure to connect before the evening's out, and we can set up a time to talk and set you up to help with these efforts. With that said, what we thought would be important today with this meeting is really to let folks know what the rights are, right? What folks do tenants have who are facing evictions? What rights do they have? How can they protect themselves around evictions? What we really hope to do, as I mentioned, is really build a network of folks that can provide information, provide support. I hope to develop a shared, I'm somewhat old, so I'm not too up to date on like Google Sheets and all of that, but we do hope to create something like a Google folder or Google Drive with resources that we can share, updates around what's happening, that can be open to folks like ANCs, like folks who represent churches, who represent community groups that are out there interacting with folks who may be in this situation. So we'll talk a little bit about that as we wrap up. But with that said, let me turn it over to Nicholas Patton from Neighborhood Legal Services Program, who's going to give us an overview of what are tenants' rights who are facing eviction. Thank you, Nicholas.
Thanks, Daniel, and thank you so much for everyone's work. You're right. Like legal support and all that stuff is really important. We have a lot of legal resources in DC, but also equally important is people knowing about these resources and being able to get connected with them, because if they don't, they will have a lot of trouble raising their own rights in court and knowing about, how important things like their first court date are, like you represented. So really appreciate it. I'm going to try to share my screen here. The PowerPoint. All right, can everyone see? It should say Neighborhood Legal Service Program right now. Yes. Okay. I've got like 3 screens and I'm just like figuring it out. Okay. I'm gonna back up And all right. Don't want to show, no. And you can see like the next slide stuff with me, right? Like that's kind of, okay. I'm sorry. Let's see if I can.
I think you still had that enable editing thing unchecked.
Oh, is that why it did it? Now it's going to do it right. No. Okay. I'm just going to do it like this. Can everyone read that? Okay.
Right now we can't see it.
Okay. All right. I'm really sorry. I'm usually not this terrible with this sort of stuff.
That's okay.
I'm gonna try this again. All right. Okay, we can see agenda. All right, I'm just gonna proceed like this instead of doing the slideshow. I think everything should be readable like this. Just let me know, stop me. So yeah, I'm gonna cover 4 topics here. I'm gonna cover basically what my program, Neighborhood Legal Services Program, type of work we do, what type of support we can offer for tenants facing eviction, and a lot of the other problems that come up that either result in someone being subject to an eviction, like losing a job or losing public benefits or an income stream. We also assist in those areas of the law. So I'll talk a little bit about not the substance of that work, but what type of problems we help with over there. And also, the things that happen after you are evicted. There's like a triangle of things that can happen. Often a medical emergency causes a debt, unable to pay rent, and then eviction, and then then you unstable housing, transportation makes it difficult to go to work. So things like that. These are all very related issues. Then we're going to talk about some of the tenants' rights, the new protections in the law with the permanent legislation since the pandemic. There are a lot of new protections, both procedural that help draw out cases longer now, and also substantive that help protect tenants in non-payment cases and other types of cases. And then how to get assistance. So the different organizations that you can go to, both for legal support and rental assistance. And I'll kind of share sort of my understanding of how rental assistance is operating right now, because that's also changed quite a bit since the state EC program closed. And now we have ERAP through Housing Counseling Services as the primary provider. All right, so NLSP, my organization, we're a nonprofit law firm. We provide legal information, advice, representation to low-income residents in the district. We also offer services in family law, consumer law, barriers to employment, student loans, wills, public benefits, and as we all know, housing. So our housing work covers tenants facing eviction. That would be the bulk of the work we do. We do voucher termination. So if you're a public housing resident or a voucher recipient and you are having issues in those situations, we assist with those issues. We assist with tenants facing housing discrimination issues, whether you're a tenant facing discrimination from your current landlord or you're applying to a new place and you face unlawful discrimination from the person you're applying. We also assist in those type of cases. And also sometimes we assist in building-wide issues representing tenants associations. Although I would say there are other organizations in the district that work more primarily in that practice. That's not a lot of what we do, but we do some of it. Okay, and so I think that's all I want to say about that stuff. I'm going to move on to some of the new protections and just some general stuff that folks ought to know anyway. So leases. So a lot of people, in addition to being sued for non-payment of rent, you'll see a lot of folks being sued as a squatter, especially, or alleging that they're not a tenant or do not have tenancy rights. We're seeing a lot of these cases now also because of the moratorium that was in place for 2 years. A lot of tenants passed away during those 2 years, whether it was from COVID or some other problem or illness. And so we're actually seeing a lot more of these cases now than we have in quite some time. So often the leaseholder will pass away, and the other people that remain in the unit that may not have been written on the lease or may not have had a direct lease with the landlord, or were in a subtenant relationship with the leaseholder, the landlord will file an eviction case against those remaining people. And just because you don't have a lease or you're not written on the lease does not mean that you do not have tenancy rights, or you're not a tenant. There are certain facts and circumstances that can give rise to your rights as a tenant, even if the landlord is trying to evict you, alleging you're a squatter. So it's really important that you get in touch with us, even if this is an issue. You have rights, even if you are not on a lease. There are other circumstances that that can create a landlord-tenant relationship. And then in the district, so one thing that a lot of folks don't realize also is that when your lease expires, so you have a lease for a year, you play out your lease, your landlord doesn't contact you to renew your lease, and you go into the next month after, you don't have to move that next month. Your lease automatically renews and turns into a month-to-month lease under the same terms as the previous lease. I run into a lot of folks on the landlord-tenant network that don't even realize this. And I've seen a lot of stories of people self-evicting, which is when they move out of their place, not knowing they have rights to remain, that just don't know about this in the district. So a landlord can only evict you for certain specific reasons, which I will talk about soon. And the fact that your lease has not been renewed is not one of those reasons. So, yeah, and so during the lease period, landlord cannot change the lease terms without the tenant's agreement. If the landlord tries to change one of the lease terms, they have to provide you with proper notice, and there has to be an agreement between both parties. It's like a sort of a contract situation. All right, so that's kind of just leases. I'm going to move on to talking about evictions in general. So sort of related to the issue of what I was talking about with people self-evicting. So landlords in the District of Columbia can only evict tenants with a court order. I don't think self-help eviction exists in any jurisdiction in the US anymore, but basically this means that your landlord cannot change the locks on your unit without obtaining first a court order, and then second first a judgment against you, and then second a court order, which is called a writ of restitution. And that writ of restitution is what allows in the district, the US Marshals to come and change the locks on your unit. And so when the eviction plays out entirely, the landlord gets a judgment against you. They ask for the writ of restitution. They are granted the writ of restitution. They must serve you with a notice that gives you 21 days of a date certain that the eviction will take place. So you'll be notified of the date. Sometimes this doesn't always happen properly. The notice isn't given. A lot of people don't know they're being evicted until very soon prior to the eviction. If this situation happens, there is a website, the Office of the Tenant Advocate, that has a list of all the evictions coming up over the next month. And I can provide that website in the chat. I will do that at the end of this presentation. But if you just Google Office of Tenant Advocate, there's a section on the website called Scheduled Evictions, and there's a list on there that updates pretty regularly, listing all the addresses for eviction. And even if you get to this phase in your eviction case where the landlord has secured a judgment and they're now seeking to evict based off the judgment, there are protections for tenants. So it's really important that even if someone has gotten through, maybe they missed their court date, they've missed their hearing, and the landlord has obtained a judgment against you and now is seeking to evict, there are still rights you can raise to either cancel that eviction, or in non-payment cases, for instance, you can redeem your tenancy, which means if you owe a certain amount of money, like $10,000 back rent, you're able to get rental assistance. They pay back all of that money. You have until the day of the eviction, and actually until the marshals come to your door, to pay that back to the landlord. And when you pay that back to the landlord, that case ends, and you do not the landlord has to start the process all over again. So point is, no matter where you are in your case, you have rights that can be raised. Okay. All right, so some more stuff about evictions. As I was alluding to earlier, there are only certain reasons in the District of Columbia that a landlord can evict you. These are, I think, most of those reasons. So the biggest one, obviously, most of the cases in landlord-tenant court are non-payment of rent. One of the new changes in the law is that the landlord can only sue you in a non-payment case if you owe more than $600. So if it's less than $600, and landlord sues you, that is a reason for the case to be dismissed. They cannot do that any longer. And we do see landlords trying this still, even with the new legislation. So a new powerful protection. So violations of your lease. So if the landlord says you're violating your lease, they can file, and they can serve you with a notice and file an eviction lawsuit against you based on your lease violation. So this comes up a lot. Smoking in the unit can something we see a lot. Criminal activity. So sometimes, there's a shooting near your unit and your landlord thinks you're involved. They may allege that you're violating your lease and serve you with a notice and try to get you out on a breach of lease issue. Obviously, the landlord has to prove all these allegations in court, and you have a right to defend these allegations in a trial. So lease violation, probably the second most common we see illegal acts. Landlord's own personal use. So if the landlord desires to move back into their property and use it as their own residence, they can sue you for an eviction based on that. Don't see that too often, but sometimes it happens. Again, you have defenses to this, and the notice period for it is much longer. I believe it is 90 days. They have to serve you with a 90-day notice instead of a typical 30 or 60-day notice in other types of cases. And they have to prove to the court that they actually want to move into the property and they're not just retaliating against you. Sometimes we see this as a pretext to get folks out of their property. Again, these other issues, we don't see these very often, but sometimes when they're rehabilitating the whole building or renovating, they will serve you with a notice for this. These have much longer notice periods. I think 120 days for things like substantial rehabilitation, conversion, things like that. And I think demolition is 180 days. So much higher notice periods. And again, they have to file a court, they have to serve you with a notice, they have to file a court case, they have to obtain a judgment, and they have to obtain a writ before they can proceed. Landlord can never just come to your unit and change the locks without that court order. That is an unlawful eviction in the district. Okay, so notices, I might have gotten ahead of myself a little bit. So 30-day notice period required for, that's not actually right, but so 30-day notice period for some types of eviction cases, things like a lease violation. You'll get a 30-day notice for a lease violation saying you're violating your lease. You'll have 30 days to fix that problem. So you get an opportunity to cure. So if it alleges, you're smoking in your unit, you have 30 days to fix whatever it is the landlord is alleging you do. And then after that, they have a right to file a case if they feel you haven't fixed whatever it is you're doing. And then, so non-payment of rent cases now have a 60-day notice. That's another big change in the law. They used to be in the district, you could waive your right to a notice for non-payment of rent in your lease. That is no longer a thing. So your lease may still say that, even though, but the law has changed. And so that lease provision is now unenforceable, and the landlord will have to use a 60-day notice of non-payment of rent before they move to evict you. Another thing that's powerful with the new legislation is there are a lot of new requirements that need to go into the notices, such as information about you do not have to leave until a court tells you. They have to give information about LT land, the Landlord Tenant Legal Assistance Network, and some other statements about your rights. That is required language in all notices, and it has to be there. It has to be at the top of the notice and stated prominently and at the beginning. And if it's not, that notice is not lawful. And if they file a case on that notice, there is a good reason that the case should be dismissed. a lot of landlords are not keeping up with this. And so it's really important to keep track of notices you receive and have them ready when you are, getting legal advice or obtaining a lawyer. There could be a really good basis for your case to be dismissed. Oh yeah, and they also have to provide it in your primary language if it's known, besides English and Spanish if it's not one of those two languages. Okay, so some other landlord requirements, so other procedural protections that have come up. So when the landlord sues you, that is, they've served you with the notice, 30 days have passed, 60 days have passed, whatever, they filed their court case. Now they have to serve you with that lawsuit, that is, give you a copy of the complaint and summons explaining why they're trying to evict. And so new requirement is that paperwork needs to get to you 30 days before your initial hearing. So you'll have a first hearing in your case. That paperwork needs to be served on you 30 days before that hearing. And it used to be 7 days. So that's much better procedural protection. Again, a lot of landlords are missing this. And so if they serve it, within 30 days of the initial hearing and don't adhere to this rule, it's a cause for dismissal. So keep that in mind as well. There are other protections. They need to provide timestamped evidence of the posting, and they must have a basic business license and a rent control registration or exemption before filing. This is kind of a technical requirement, but it can be very powerful if your landlord does not have a basic business license to rent out property in the district. That is, maybe they're a small landlord trying to do things under the table, trying to not report their income to the tax authority, so they don't want to get a basic business license. If they don't have one, they can't move to evict you. That's going to be a dismissal if they're unable to provide that they have a business license or present it to the court. They have to do that before basically at the time they file. So when they file their case, they have to present it. They can't present it later. Okay, so that's a lot more landlord requirements. So eviction record sealing. So sort of moving to, if you've been evicted in the past or have an eviction on your record, there's some new updates to that law about what's happening there and how that can be used in applications at subsequent landlords. So any case without a judgment will be automatically sealed 30 days after resolution. So this is what the law says, but this is not what I've noticed. It is not really happening too much in practice. So if your court case is resolved or settled, or there's no judgment entered against you, you win the case or it's settled, that case should be sealed 30 days after that result. It's not. I'm noticing that it's not really happening with regularity. I would recommend if you have gotten your case dismissed or you've paid off your arrearage before the judgment or it's been resolved, I would check on it. I'll provide the website for court view. You can look these cases up online. And if your case is still there, you can contact the clerk of court. And after that happens, I've noticed that they're getting sealed quite quickly. So if you provide your case number to the clerk of court, that will get fixed right away. But I'm just noticing that it's really not happening 30 days after resolution. All other cases, so cases where a judgment gets entered against you, sealed after 3 years. And then there are some reasons now that you can have a case sealed if it's within the 3-year period. So for instance, again, this is the new sort of powerful legislation that's in pass. If your judgment was for less than $600, if you were evicted while you lived in subsidized housing, if you can show the landlord retaliated or committed violations under the DC Human Rights Act. So those would be discrimination allegations. Landlords did not repair housing code violations, and there's a defense based on stalking domestic violence. You were never actually evicted, so you got to the point where, like, landlord got a judgment against you, they got a writ against you, and you paid off the arrearage, and it stopped the case there. That case should also be sealed. So that's what they mean by tenant was never evicted. And then there's a catch-all for other good cause. So perhaps there are other circumstances that could give rise to a reason for a record sealing. Okay, I'm gonna try to move a little quicker, Daniel. I'm sorry. I know. Okay, I'm good on time. Okay. Okay. I just wanted to say one thing about record sealing too, because like just in practice, like one thing that I'm noticing is that um landlords use these background check companies when you apply to new places, and the way they work is they pull records of a court in a snapshot in time. So you will apply with a new place, you'll do a background check, and your eviction will come up, even though even evictions that have been sealed will still come up because they're the whatever system they use that does the nationwide court check grabbed a screenshot of the system from a year ago, and so your eviction was still there. Obviously, if the landlord uses this, this is unlawful discrimination in the district, and they're subject to a civil suit if they don't, reverse their determination from you. And you should contact us or other legal services providers if that happens. But I'm noticing quite a bit that landlords do not realize this legislation is in place, and they also do not realize, that these evictions are sealed because they're whatever system they're using to do the background check isn't just not up to date. Okay, so late fees. So pay your rent later than the requirement. So I think in DC now it's after the 5th. If you pay after the 5th, you're subject to late fees. Late fees cannot be more than 10% of your rent, and you cannot be evicted for late fees, and late fees are not part of the redemption amount. And so this means that if you pay, if you acquire like a substantial arrearage, $5,000, a decent amount of that is going to be late fees at some point. That the late fees are going to be deducted from the final amount that's required for you to pay to stay in the unit and to stop the lawsuit against you. And so a thing about ERAP is, I wrote maybe in here because Lori wrote that ERAP will cover late fees. So ERAP will cover late fees, but so there's a certain number that ERAP will go up to rental assistance right now. And I think it's like 3 or 4 months, and it depends on where you are and how much your rent is. So someone can correct me on that if they have much more specific information, but this is just what I've been seeing. Daniel, did you have something to say about that?
No, just in case folks don't know, it's the Emergency Rental Assistance Program.
Yes, thank you. Yeah, so this is the current program that's in place for rental assistance in the district. It can be accessed at DHS's website, and I think I have a link for it at the end of this presentation. I'll provide it if it's not in here. But so when you apply for rental assistance, you can get up to 3 or 4 months rent. If your arrearage is substantially higher than their guidelines, you can request a waiver from ERAP to pay off the entire arrearage to stop the eviction. It's not always guaranteed that that will happen, but some of the questions they'll be asking when you request that waiver are things like, well, if we pay off this full amount, like what's going to happen next month? Can you show that you're going to be able to pay the rent next month? What's your income looking like going forward? Are you willing to do financial counseling to sort of improve your income situation or your planning abilities for going forward? So they'll be asking some questions about that. And if they are able to do the waiver process, they will deduct the late fees from that amount. But I think as long as you're under the guidelines, ERAP will cover late fees. Okay, so repairs. Repairs and housing code violations are really important. It's just a constant in DC. The landlords do not, do enough to provide safe and habitable housing to tenants. Every case I run into, there are substantial housing code violations, many of which are related to health and safety problems. And as we know, many district residents suffer from chronic illnesses such as asthma that can be exacerbated by these problems if they're not remedied. So it's really important that these issues are raised as soon as they can be. And I know it is frustrating to ask landlords to repair things and send things to them, knowing that they're just not going to do anything about it until they get sued or until you contact a lawyer or things like that. But it's still really important that you do this, because what it does is it creates a record of you contacting the landlord, telling them about housing code violations, and then doing nothing. Once you have that record, it's really important And if you find yourself in a non-payment of rent case, it can be a very powerful defense, and can lower the amount that is owed by the landlord, because you can argue that the rental unit was actually worth far less than what the landlord is asking for, because they've refused to fix their housing code violations, which is required under their lease and under DC law. So yeah, so things like, extermination, mold, lead, locks, leaks, appliances, outlets, paint on the wall, shipping paint on the walls, just anything you can think of in the unit that's not going right. You should make sure to give your landlord notice about these issues, even if you know that they're unlikely to do something in a reasonable amount of time. One thing we run into a lot is access disputes between tenants and landlords. Landlords are very known to use this access ability they have into your unit and abuse it. So you want to be aware that there are only certain reasons landlord can come to your unit. They have to give you 48 hours notice for non-emergency repairs. And when they do that, they have to provide some information about what they're doing in the unit. So, they can't just say, we're going to be there all day. We're going to be there all day and we're going to work all over your unit. No, they have to give you some reasonable time frame, and they have to give you some information about the type of work they're doing for the 48 hours written notice to be valid. And it's important that think about. I know that having a slumlord and going back and forth about repairs and all this stuff is incredibly traumatizing, and it can be very hard to come to agreements about access. But I advise clients to think about, down the road, if you're in front of a judge on this issue, you want to make sure that you have your documentation. You want to make sure that you appear to be the most reasonable party, even if your landlord is being abusive and unreasonable. So if you constantly deny access without good reason, it can be used against you later when you're trying to argue these housing code violations. Landlord can argue that they're not fixed because you've been denying access, even if that's an incredibly unfair argument. Okay. Oh yeah, I was kind of getting ahead of myself here, but again, I can't emphasize enough how important it is with housing code violations. The second you see violations, put them in writing. Don't, some landlords don't give you an entryway to do like tickets and emails and things like that. I would say if you have someone's number, make sure it's textable, or get an email so that you can you need to be able to show that you're making these requests. And a lot of people just call the maintenance office, and unfortunately it's going to be very hard for you to show that you've called them over and over when it comes time to prove in court that you've notifying them of the violations and they've done nothing. So get an email, write down what's going on, send it as often and as soon as you can. And if you end up doing repairs yourself because the landlord's not fixing them, keep receipts of those things. Okay, yes, photos, names of people you talk to, date and time of conversations, this stuff is all very, very helpful, very important. Okay, and I think that's sort of all I've got for the basics and some of the updates in the legislation. And I'm going to share some contact information for our program, and for this is LT Land, the Landlord Tenant Legal Assistance Network, is the primary way in the district to get legal assistance for landlord tenant issues. You call that number, you're going to get an attorney from NLSP or Legal Aid or Redford the City or Rising for Justice, one of the organizations. We all work together to staff this resource. So it's incredibly useful. And I'm going to put my information to, I'm sorry that I haven't been reading the chat. I ended up a different screen. I've got a section here. Okay.
I wanted to flag, Nicholas, that LT Land, while I think it's open till 5, I think like at 4 they start to stop taking calls so they can like finish the ones they may be in the middle of listening to folks and doing the kind of intake part of it. So just FYI, probably best
Especially lately. Yeah, it has been quite swamped the last couple of weeks. I staff it on Tuesday afternoons. So if someone wants to call and talk to me, I'll be there Tuesday afternoons. But yeah, and I have heard from a lot of people that they have trouble getting through. Like sometimes I'll have to call, 2 or 3 times before they actually get through, or call and do there's like on the website, I think there is a place where you can do an online intake. I recommend doing both because sometimes you can't get through, and it's really important that you do, because if you're not able to get through, then you're not going to get on the list for a callback. And sometimes your problem is you have a hearing next week or something. You need to get in touch with them. Okay.
Are you able to take some questions?
Yeah, sure.
All right. I think Judy had one in the chat. Judy, if you want to come off mute and just ask it, that'd be great. Or
sure. Yeah. We're dealing with a case where I actually think the landlord did manage to follow the many requirements that you listed, and it's for non-payment of rent. This resident has applied successfully for CDC in the past and then recently applied for ERAP, but unfortunately, it's not, even with the ERAP, they're still months behind on rent. So at this point, sort of wondering, what are the next steps? I know that we have called the line to match this person with support, legal support, but I'm just wondering, I feel like I remember something about it being very helpful for your case to show that you have a history of applying for emergency rental support. And B, I also remember, and maybe it was just under the emergency, that the landlord was required to come up with a payment plan. Just wondering if you would talk more about the cases of non-payment of rent for folks, particularly given that ERAP just isn't sufficient for some of the rent that's owed. And as you know, there's such a backlog and such a waiting period that by the time you even get the money, then that's just like, okay, great, that was from 4 months ago. Now you're still in debt.
Yes, thank you. That's a great question. So there are, yes, I don't think I mentioned that actual additional protection that is in the new legislation, that the landlord does have to offer a payment plan, and the tenant has to either the payment plan, or the landlord has to offer a payment plan, and the tenant, if the payment plan, I'm not exactly remembering what it is, but there's 3 things the landlord has to assert. One of them is that they have, tenant has applied for ERAP or CDC, and that program has been applied for and they've been approved, and the amount that's been approved, it will not cover the arrears. The landlord has to assert that before they, on their complaint, that process has gone through. And they also have to assert that if the arrearage is a certain amount, that they have to have attempted a payment plan with the tenant and it's not been able, and the tenant has breached the payment plan. I believe that's the other part. I'll get back to you with the exact provision there, but there are some statements the landlord has to make on their complaint about that. They do have to show that if there was an ERAP application, that it was either denied or it was approved and the arrearage is still over $600. And also at the end of the case, if the landlord obtains a writ of restitution, they have to check within, I think it's 3 days before the eviction date. And if the tenant has a pending rental assistance application, the eviction is supposed to be canceled. I've noticed that landlords are not doing this. So it's very important that if you have a live writ and you have an ERAP application that's pending, that you call LT Land and have an attorney help you assert those rights. Because I've noticed that landlords are just not really following that process.
let me add, I spoke recently to Housing Counseling Services, who's one of the organizations that's helped to disperse the ERAP funds. And they shared with me a phone number that I just put in the chat. I'll write up some notes, and I've got everyone's email, so I'll send all this information, but just wanted to to let folks know, that is a number. The online application can be a little cumbersome. The whole process can be a little cumbersome, not a little, a lot cumbersome. So this call center number is staffed by the organizations that disperse the funds, and you can call and get some help in applying, like the process of applying. And anybody that is helping tenants in this situation, even if you, because the process is cumbersome, what our friends at HCS, Housing Counseling Services, suggest is start that application. Start it so it's on file, it's on record that you've begun the process. Of course, you don't want to just like leave it alone and forget it. But you know, even if you don't have, because you know, a lot of times you have to get documents, you have to scan them. That takes a while accessing those, remembering where they are, and putting them all together. But starting the application is a good move especially on somebody that's, you know, faced with a court date right that's coming up. So just wanted to flag that as well.
Yeah. And so wait, Nicholas, just to clarify, so it is still the case under current law that in order to move forward with an eviction notice, there has to be proof that the landlord tried to have a payment plan and that the tenant has violated that?
I think that was the case during the temporary legislation. I don't think that it's necessarily the case right now. I'm going to get back to you on that question, but I don't think that, I think it's if they've established a payment plan, the tenant has to be 2 months behind on the payment plan for them to proceed. I believe that's the rule. I don't think that there is a rule that says they have to have entered into a payment plan prior to filing the eviction. But I'll get the answer to that for you, Judy, if you.
Yeah, I'll put my email in the chat as well, but I have yours. Thank you so much.
And then I was going to say something about ERAP, practically speaking. So right now, it seems to me there are 3 tiers of priority for ERAP people because it's taking a very long time to process the applications. The first tier of people are people who have live writs. So if you have a live writ, your application is moved to the top. If you're, which means that the landlord's obtained a judgment and is seeking to evict you. Second tier is going to be people who have a court case filed against them. And then the third tier is going to be people who have just received a notice or have not yet been sued by their landlord. So just keep in mind that there are long waiting periods for folks that are lower on the priority with rental assistance right now. And I know people are frustrated about that. But keep track of your rental assistance application, the confirmation number, and keep checking on HCS about the status of your application.
Any other questions from folks on this piece? You can always send us an email. As I mentioned, I'm going to be writing up some notes as a follow-up to tonight's meeting with some of the information that's been shared. Judy, another question?
Yeah, but I can wait to see if somebody else wants to go.
Sure.
I was actually wondering, I'm sorry, I can't remember if it was Daniel or Nicholas who said this, about the waiver that you can request, which it sounds like you could, this is again, applying for ERAP. It sounds like you can only request this waiver to cover all arrears if you had some sort of either the live writ or the notice, right? So you definitely you have to be far enough in the process of eviction that you have something from your landlord, it sounds like. I did not know about that. That's interesting. It's also frustrating. I just like the system is just like driving people to get as much in debt as possible and then be at risk for eviction in order to actually get help, which I won't even go on my soapbox, but it's just very frustrating to hear that that is what the system is literally driving them to do strategically if they want to get as much rent coverage as possible. So is that correct that in order to request that waiver, you would have to kind of request it from the beginning of the process. Meaning, if you've already started an application with ERAP and you started like, you're just gathering the documents, is it possible to go back and say, actually, we want to request a waiver to request more money?
I think the way it works is you apply, and ERAP will, they'll approve a certain amount. And I do believe that indeed you do have to, I agree with you that the system is incredibly flawed and it's not great, it sucks. But I think you have to be at the stage of a live writ where you can request the waiver. And then the waiver, they're going to ask you those questions like I mentioned. If we pay this all off, are you going to be able to pay next month? What's the plan? Are you willing to do financial counseling? Things like that. And those guidelines are also changing too as things move on. So I don't know if I've successfully done a waiver in the last month or so. I don't think I've actually had to ask for one, but I was able to get one through back in May. So that was a couple months ago. So it is still an option. I do know that. I just don't know how often right now they're approving them or under what circumstances. I'm sorry if that's, that's not really totally tangible information, but the program can be quite nebulous.
Yeah, no, that's helpful to at least have as an idea. Thanks.
Well, thank you, Nicholas. I don't know if you're able to, if you could share the presentation with us, we'll make sure to put it in this resource folder that we'll put up, and we can update as needed. As you mentioned, some of this stuff is changing. So we'll keep updating it, but that would be great. Unless there's no other questions rather, I'd like to shift to the next presentation. Are there any other questions on what Nicholas presented? Does not appear to be. Thank you. So thanks again, Nicholas. That was super helpful. I mean, I think at the end of it, it is, the system is tough. Everybody's waiting for something, but there is help out there. I think that's the biggest takeaway for me in all of this is that, even when it looks you're in the worst time in all of this, like facing the marshals, there is help and support out there that can be sought. Of course, it's part of our work is to get out there and contact those folks and let them know what's happening. So with that said, oftentimes I know landlords do not appreciate organizers or activists going into their buildings and saying to their residents, hey, you have rights. They will try to keep you out of their buildings. They'll call security on you. They'll call police on you. And so I thought, because many of us are engaging in these efforts of, going out there to talk to people who are in these situations or like right at their homes, knocking at the doors, that it'd be important to know our rights to organize. And Kelechi from the Washington Lawyers Committee is going to give us some brief pointers on these rights and how we can avail ourselves of them, and residents themselves can avail themselves of these rights. So Kelechi, if you're ready, go right ahead. If you do you need to present anything? I can make you a co-host.
That's fine. I think that I can kind of do it from here and just explain it. I think it's pretty self-explanatory, but I do want to make it clear for people, because I think that a lot of times, because people don't understand that these rights are enshrined in law, they're not sure how to enforce these. But under DC code, there are certain protected actions that every tenant has that are legally protected, that the landlord can't interfere with, either in their rules or in their practices, meaning how security or staff interacts with you. And excuse me, among those activities, the landlord is not legally allowed to interfere with a tenant forming, joining, meeting with, or assisting one another, whether that be inside or within the confines of or outside of recognized tenants association. So you can meet, you can join with your tenants, you can have an organized response to a landlord action or to actions in the general community. You can choose representatives of your own choice and meet and choose to meet with management to discuss these concerns. You can engage in other concerted organizing activities that are for the purpose of mutual aid. And when you're doing these things, management can't interfere with you doing these things in shared space. So you can do any of the actions that I've spoken about in lobbies, in hallways, in tenants units, etc. Beyond that, tenant organizers, so non-tenants who are invited by tenants to help them organize and do organizing activities, are allowed to canvass on the property with the same rights as a guest that any guest have, unless there's a consistently written and enforced policy against canvassing. And even if there is a consistently written and enforced policy against canvassing, organizers can still canvass, can still knock on doors, can still talk to other tenants, can still hand out flyers on tenants' doors and under their doors and on bulletin boards, as long as they're invited by a tenant association member and are with a tenant association member. So that right extends beyond just the tenant themselves, both to tenant organizers that they're invited and to non-tenant organizers who are guests of the tenant. And so, like I touched on just a little bit, some other organizing activities that are protected under law, distributing literature in common areas, including lobbies and hallways, placing literature under tenants' doors, and posting information on all of the bulletin boards. And if you do not have access to a bulletin board, if it's behind a locked area, tenants and others must be given access. If the landlord has a bulletin board or a part of the building that for some reason or another they're deciding they don't want tenant organizers to canvass, tenants themselves can request access to those areas. Also, tenants have the right to convene a meeting at a reasonable time and in an appropriate space that would be reasonably interpreted, as areas that the tenant has access to under the terms of their lease. And that's an important one. So in a lot of situations that we've seen, management will deny access to spaces on the property to organize. They'll say that a community room or another space isn't available. They'll discourage or they'll call the police on tenants if they organize in the lobby or in the hallways. But this specifically says you have the right to meet in any space that's reasonably interpreted as you having access to. So if there's a community space that the management is saying is locked for erroneous reasons, you can make that request. And you can request that management give you access to that space under the penalty of this law. I'm going through a few notes. I don't want to gloss over anything. Also, obviously, the landlord cannot retaliate against you for organizing. And this kind of goes into some of the things that Nicholas was mentioning earlier. Retaliation may be any adverse action by the landlord against a tenant that's engaged in organizing activities. And those steps can be verbal or written. And, sorry, just scrolling through, but it's important to recognize when a tenant is being retaliated against, because along with the protections offered under this statute, under the DC housing statute, a tenant cannot be evicted in retaliation for their organizing activities. And a landlord and a tenant who is engaged in organizing activities is given a rebuttable presumption if the landlord tries to evict a tenant who is engaged in organizing activities, there's a rebuttable presumption that it's retaliatory. A lot of word soup, but meaning if you're engaged in organizing activities within 6 months of the landlord trying to evict you, the landlord has to prove that they are evicting you for a retaliatory reason before they can move forward with that eviction. And so along with the protection that offers you, if you were to be threatened with an eviction by the landlord can be hit with a civil fine or potential suspension of their business license for multiple violations of the right to organize statute. So it's something that we want to monitor and that our organization is working to try to build some case law around. So if you believe that your landlord or you believe that landlords have been violating a tenant's right to organize, I would definitely be interested in learning more about that and talking to you more. I'm going to leave my information in the chat, but I think that's everything that I had as far as the right to organize statute. And I am available for questions if anyone has any.
Awesome. Thank you, Kelechi, for that. I mentioned I thought it was important to touch on that because we have come up on those situations where, you know, we've gone into a building and they've said, what are you doing? Why are you handing that out? Even if you were invited by a tenant, oftentimes, management, owners will not want you in their buildings. So we definitely want to be able to track those, pass those on to the Washington Lawyers Committee, who is tracking that and taking action on that. It is about 7:38. I want to, unless there are any questions, I just wanted to move to some general next steps. What we want to do from here is really build, like I said, either both a network and an archive of resources for ANCs, for community-facing organizations, for individuals in general, really to have a place to go to if they have questions, if they need, to connect to legal support and even to ERAP, which can be quite a bit. But we are going to start building that. If you all are, unless you don't want to be included in that, please let me know, either drop something in the chat or send me an email. But we will go ahead and begin building that, give you access to it, so you can have the information there that you can use either for your own presentations or if you're going out there talking with folks. There's a flyer that we've developed that we're using for this outreach to connect people to the LT Land, the Landlord Tenant Legal Assistance Network, that we will definitely put up there, that you can either print out yourself or ask us for some printed copies. We can certainly help with that. I think the cases are definitely on the upswing. Capacity is a big issue, both in outreach and in being able to actually cover each and every one of these evictions, but we are going to try to do the best we can. I think the great thing about this is that there's been more of a deliberate effort of legal serving organizations, on the ground organizations, ANCs, community serving organizations coming together to really put a formal system in place that helps us to fight evictions. Of course, the bigger picture stuff is, why are there even evictions? But that's a whole other meeting that we will convene at some point. But right now, there is that immediate threat, so we know it's important to get out there and do this work. If you would like to volunteer, if as I mentioned, if you represent an ANC, a church, a community group that knows there are a lot of buildings, rental units in your in your neighborhood or where you're based out of. If you'd like to do some general outreach, please feel free to give me a call, email. I'll make sure to drop that in the chat before we wrap up. We can provide you with flyers, with just some general information. Also, if you are interested in helping us out in reaching out to, prior to this kind of effort, of this concentrated effort of organizations going out, it was a volunteer effort of people going out to talk with folks who are either on the eviction roll or the have a court date against them. Right now it's becoming a little more formalized, but we still need that volunteer help. So if anybody is interested in volunteering, setting up an outreach day, please don't hesitate to ask, and we can provide you with as much support as we can. And potentially, if you are based in a neighborhood and there are evictions there, we can certainly work out a way for you to connect with those folks as well. So we can, make sure that we're getting out there as far as we can and reaching out to as many people as possible. With that said, I don't want to keep us too much longer. Are there any other questions or anything people would like to add?
Hello.
Hello.
Good evening, everybody. My name is Falashade Pine. I am a resident of Ward 3, DC native, grew up in Ward 4. And I came on the call today because I am hosting a live talk. I don't want to call it a talk show. It's a panel discussion, but it'll be live and recorded. And it's in collaboration with the Humanities DC Commission. And so I came on today because the topic that we'll be discussing is gentrification. And I would love to have, folks who are attending tonight and folks who are experts in this work come out to the event. It's going to be September 1st. I definitely am going to copy your emails so I can make sure you guys get the invites about it. But we're also looking for, really strong panelists. So if anyone is interested in, coming in to speak specifically about gentrification, I know that it's directly impacted, directly tied to evictions, the gentrification in Washington, DC. So just want to share that. I'm going to drop my email in the chat as well and save the emails that are here now. So thank you all again for this conversation tonight.
So thank you for that. We'll make sure to add that to the notes when we send them out to the group that attended.
Thank you.
And registered. So we'll try to send as much. Lori?
When did you say you were organizing that talk for? What time? When?
September 1st. So it'll be September 1st at a restaurant called Glories. And it'll be in the evening at about 7 p.m. But we're getting the Eventbrite up now. We don't have it up just yet. But if you're interested, definitely just drop your email and I'll make sure that when we have that up, that we'll get you on it.
Great. Thank you.
Thank you.
Awesome. Well, I know there's a lot of information being dropped in the chat. As I mentioned, we'll make sure to consolidate all of that into one email, and then of course into this resource folder, for lack of a better term, that'll be accessible online for everyone to have access to.
Okay. So we just contact you if we're wanting to volunteer sometime to reach. Okay.
Yep.
So it's just we directly contact you.
Yeah.
Okay.
Yep. Yeah, that sounds great.
Okay.
All righty, folks. Well, it is 7:45. We can enjoy this 90-degree weather, or it's maybe down to 80 now, for the rest of the evening. But thank you all so much for joining us this evening. We've got your contact information now, so we will keep forwarding information to you all as it comes up, any pertinent information, anything that's good to know for these efforts. We'll make sure to keep on passing that information. I want to thank Nick, if I can call you Nicholas Patton from NLSP, Neighborhood Legal Services Program, and Kelechi Agbakwaru from the Washington Lawyers Committee on Civil Rights for their presentations this evening. Super helpful. And yeah, let's just keep working at this, make sure that we can protect as many people as possible. And we will be in contact with everyone. Enjoy the rest of your evening.
Thank you all so much. Have a good night.
Hey, everyone.
Thanks. Good night, everyone.